Okay, so magandang gabi sa inyong lahat. Nandito na naman ang inyong Lolo Ray para magbasa-basa na naman ng mga batas, no? At sa pagbabasa natin ng batas, susubukan natin tong ipaliwanag in layman's term, di ba? Okay, so mercantile law pa rin tayo. Babasahin naman natin ngayon ang Intellectual Property Code of the Philippines, RA 8293. Okay? Okay, Part 1, the Intellectual Property Office. Okay. Section 1, this act shall be known as the Intellectual Property Code of the Philippines. Section 2, the state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investment, and ensures market access for our products. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such periods as provided in this act. Okay, sabi niya, the use of intellectual property bears a social function. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress and the common good. It is also the policy of the state, okay, to streamline administrative procedures of registering patents, trademarks, and copyright, to liberalize the registration on the transfer of technology, and to enhance the enforcement of intellectual property rights in the Philippines. So yun pala, yun ang polisiya ng ating estado. Diba? Tinitignan niya yung kahalagahan ng ating mga scientists, inventors, artists, lalo na yung kung yung kanilang creations ay talagang makakatulong para sa pangkalahatan, ano. Section 3, magtungo tayo sa Section 3. Okay. International conventions and reciprocity. Any person who is a national or who is domiciled or has a real and effective industrial establishment in a country which is a party to any convention, treaty, or agreement relating to intellectual property rights or the repression of unfair competition, to which the Philippines is also a party, or extends reciprocal rights to nationals of the Philippines by law, shall be entitled to benefits to the extent necessary to give effect to any provision of such convention, treaty of reciprocal law, in addition to the rights to which any owner of an intellectual property right is otherwise entitled by this act. Okay? So tayo daw ay party to a convention, mga treaties and agreement na may kinalaman sa intellectual property rights, no? Okay. Section 4, definitions. Okay. The term intellectual property rights consists of, okay, letter A, copyright and related rights. Letter B, trademark and service marks. Letter C, geographic indications. Letter D, industrial designs. Letter E, patents. Letter F, layout designs. Ito yung mga topographies of integrated circuits. And letter G, protection of undisclosed information. 4.2, the term technology transfers arrangements. Yeah. The technology transfers arrangements refers to contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product, the application of a process, or rendering of a service including management contracts, and the transfer, assignment, or licensing of all forms of intellectual property rights, including licensing of computer software, except computer software developed for mass market. So, ang sabi niya, hindi kasama yung computer software na dinevelop para sa mass market. 4.3, the term office refers to the intellectual property office created by this act. 4.4, the term IPO Gazette, okay, refers to the gazette published by the office under this act. Okay, kung familiar kayo doon, di ba, meron yung official gazette kung saan pinapublish ng ating gobyerno yung mga bagong batas. So sila merong Intellectual Property Office Gazette publishing, and siguro sa panahon ngayon meron na ring website para dyan. Section 5, Functions of the Intellectual Property Office. Ano ba yung function nila? 5.1, to administer and implement the state policies declared in this act. There is hereby created the Intellectual Property Office, which shall have the following functions. Letter A, examine applications for grant of letters patent for inventions and register utility models and industrial designs. Letter B, examine applications for the registration of marks, geographic indication, integrated circuits. Letter C, register technology transfer agreements and settle disputes involving technology transfer payments covered by the provisions of Part 2, Chapter 9 of Voluntary Licensing, and develop and implement strategies to promote and facilitate technology faster. Letter D, promote the use of patent information as a tool for technology development. Letter E, publish regularly in its own publication the patents, marks, utility models, and industrial designs issued and approved and the technology transfer arrangements registered. Letter F, administratively adjudicate contested proceedings affecting intellectual property rights. And letter G, coordinate with other government agencies and the private sector efforts to formulate and implement plans and policies to strengthen the protection of intellectual property rights in the country. Balikan natin letter F. Sabi nila, administratively adjudicate contested proceedings. Function niya rin yan. Ibig sabihin nito, parang yung mga final na kasong administratibo, no? Laban sa na concerning or affecting intellectual property rights ay pwedeng pagdesisyonan, merong administrative power to adjudicate itong IPO o yung Intellectual Property Office. Di ko nga lang alam kung saan ka aapila sa desisyon nila. Kung aapila ka ba sa Court of Appeals or aapila or diretso Supreme Court. Ang tingin ko Court of Appeals. 5.2, the law shall have custody of all records, books, drawings, specifications, documents, and other papers and things relating to intellectual property rights, applications filed with the office. So, dapat kompleto ang kanilang record ng mga applications sa kanilang office. Section 6, the organizational structure of the IPO. The office shall be headed by a Director General who shall be assisted by 2 Deputies Director General. 6.2, the office shall be divided into 6 bureaus. Okay, 6 na bureau, each of which shall be headed by a director and assisted by an assistant director. These bureaus are letter A, the Bureau of Patents, letter B, the Bureau of Trademarks, letter C, the Bureau of Legal Affairs, letter D, the Documentation, Information, and Technology Transfer Bureau, letter E, the Management Information System and EDP Bureau, and letter F, the Administrative, Financial, and Personal Services Bureau. Meron akong kaibigan na nakapasa na siya sa bar exam, isa na siyang abogado. Bago siya mag-exam, tinanong ko siya kung anong pangarap mo pag naging lawyer ka na. Parang sabi niya, ang gusto niya ay parang magtrabaho rito sa IPO, Intellectual Property Office. Parang gusto niya daw tumulong doon sa mga inventors natin, ano? May kinalaman sa technology. napakaganda sana. Pero ngayon nakakatulong naman siya sa malaking bagay din dahil siya naman ay abogado ng Office of the Solicitor General, no? Okay, magtungo tayo sa 6.3, the Director General. Deputies Director General, Directors and Assistant Directors shall be appointed by the President and the other officers and employees of the office by the Secretary of Trade and Industry conformably with and under the Civil Service Law. Section 7, okay, sabi niya doon Okay, alinsunod itong mga appointments na ito sa Civil Service Law. So, Presidente ang mag-a-appoint pala. Sana dumating yung araw, i-appoint yung kaibigan ko na yon kung sakaling applyan niya na maging Director General, pinakamataas, Deputy or Director o Assistant Director, no? Abogado naman siya. Kaya lang palakasan na yan syempre. Pero sana, kasi yung kaibigan ko na yon ay nanggaling sa hirap yon at nakikita niya yung importance ng pagsusupport sa ating mga inventors, artists, etc. Section 7, the Director General and Deputies Director General. Ito yung functions. The Director General, ito yung pinakamataas sa IPO, shall exercise the following powers and functions. Letter A, manage and direct all functions and activities of the office, including the promulgation of rules and regulations to implement the objectives, policies, plans, programs, and projects of the office. Provided that in the exercise of the authority to propose policies and standards in relation to the following, number 1, the effective, efficient, and economical operations of the office requiring statutory enactment. Okay? Yung mga, siguro, ito yung nagpo-propose sila sa Kongreso ng mga batas, no? Number 2, coordination with other agencies of the government in relation to the enforcement of intellectual property rights. Number 3, the recognition of attorneys, agents, or other persons representing applicants or other parties before the office. And number 4, the establishment of fees for the filing and processing of an application for a patent, utility, model, or industrial design, or mark, or a collective mark, geographic indication, and other marks of ownership, and for all other services performed and materials furnished by the office. The Director General shall be subject to the supervision of the Secretary of Trade and Industry. Okay, so siya, Director General, siya yung pinakaamo sa Intellectual Property Office, pero subject siya sa supervision ng Secretary of Trade and Industry. Letter B, exercise exclusive appellate jurisdiction over all decisions rendered by the Director of Legal Affairs, the Director of Patents, the Director of Trademarks, and the Director of the Documentation, Information, and Technology Transfer Bureau. Okay, so pag may mga administrative na kaso na isinampa, no, sa iba't ibang mga bureau, etong si Director General, sa kanya aapila. Okay? Yun ang ibig sabihin nito appellate jurisdiction. Okay, the decisions of the Director General in the exercise of his appellate jurisdiction in respect to the decisions of the Director of Patents and the Director of Trademarks shall be appealable to the Court of Appeals. Uy, tama ako. In accordance with the rules of court, and those in respect to the decisions of the Director of Documentation, Information, and Technology Transfer Bureau shall be appealable naman to the Secretary of Trade and Industry. Okay, kapag naman may kaso ka, may administrative case ka sa Director of Documentation, Information, and Technology Transfer Bureau, hindi ka naman aapila kay Director General, kundi aapila ka daw sa Secretary of Trade and Industry. Letter C, exercise original jurisdiction to resolve disputes relating to the terms of a license involving the author's right to public performance or other communication of his work. The decisions of the Director General in these cases shall be appealable to the Secretary of Trade and Industry. Okay, 7.2, no? Section 7, 7.2. Ano ba yung qualifications ng Director General? Sabi rito, yung Director General and the Deputies Director General must be natural-born citizens of the Philippines, at least 35 years of age on the day of their appointment. Pwede na si ano dito, yung friend ko rito. Holders of a college degree and of proven competence, integrity, probity, and independence. Provided that the Director General and at least one Deputy Director General shall be members of the Philippine Bar. Ayan, pwede siya. Abogado na siya. Who have engaged in the practice of law for at least 10 years. Ay, hindi pa pwede. 1 year pa lang siya. So, mga ano pa siya. Mga 45 years old, 46 years old siya. Doon pa lamang siya pwede ma-appoint dito. 10 years na kailangan nagpa-practice ng sa bar. Provided further that in the selection of the Director General and the Deputies Director General, consideration shall be given to such qualifications as would result as far as practicable in the balanced representation in the Directorate General of the various fields of intellectual property. 7.3, in term of office, the Director General and the Deputies Director General shall be appointed by the President for a term of 5 years and shall be eligible for reappointment only once, provided that the first Director General shall have a first term of 7 years. Wow! Kasing haba yung term nito ng mga constitutional bodies, ng mga COMELEC chair, ng civil service chair, 7 years. Appointment to any vacancy shall be only for the unexpired term of the predecessor, sabi niya. So kung kunwari, nag-retire na yung sinundan mo, meron pa siyang, hindi niya natapos yung term niya na 7 years. So may vacancy, in-appoint ka, 5 years pa lang ang nabubuno nung nag-retire o namatay. Meron ka pang 2 years. Doon ka lang pwedeng i-appoint daw, sabi. 7.4, the Office of the Director General. The Office of the Director General shall consist of the Director General, ito yung pinakamataas dito, and the Deputies Director General, their immediate staff and such offices and services that the Director General will set up to support directly the Office of the Director General. Section 8, Bureau of Patents. The Bureau of Patents shall have the following functions. 8.1, search and examination of patent applications and the grant of patents. Ikalawa, registration of utility models, industrial designs, and integrated circuits. Ikatlo, conduct studies and researches in the field of patents in order to assist the Director General in formulating policies on the administration and examination of patents. Okay, yun ang gagawin ng Bureau of Patents. Yan na naman gagawin ng Bureau of Trademarks. Mga bureau ito under the Intellectual Property Office. So Section 9, the Bureau of Trademarks shall have the following functions. Una, search and examination of the applications for the registration of marks, geographic indications, and other marks of ownership, and the issuance of the certificates of registration. Ikalawa, conduct studies and researches in the field of trademarks in order to assist the Director General in formulating policies on the administration and examination of trademarks. Punta tayo Section 10. The Bureau of Legal Affairs. The Bureau of Legal Affairs shall have the following functions. Una, hear and decide opposition to the application for registration of marks, cancellation of trademarks, yan, didinggin nila yan. Subject to the provisions of Section 64, cancellation of patents, utility models and industrial designs, and petitions for compulsory licensing of patents. Ano pa yung ano yung mga doon sa mga nabanggit na yon? Ano yung gagawin nila? Letter A, exercise original jurisdiction in administrative complaints for violations of laws involving intellectual property rights. So yung Bureau of Legal Affairs, merong original jurisdiction in administrative complaints for violations of laws involving intellectual property rights, provided that its jurisdiction is limited to complaints where the total damages claimed are not less than 200,000 pesos. Provided further that the availment of the provisional remedies may be granted in accordance with the rules of court. The Director of Legal Affairs shall have the power to hold and punish for contempt all those who disregard orders or writs issued in the course of the proceedings. And letter B, bukod sa pag-exercise ng kanilang original jurisdiction sa administrative complaints, sa violations of laws involving intellectual property rights, after formal investigation daw, the Director of Legal Affairs may impose one or more of the following administrative penalties. Pwede siya mag-impose ng mga kapurusahan na babanggitin natin. Okay, number 1, the issuance of a cease and desist order which shall specify the acts that the respondent shall cease and desist from and shall require him to submit a compliance report within a reasonable time which shall be fixed in the order. Ikalawa, the acceptance of a voluntary assurance of compliance or discontinuance as may be imposed. Such voluntary assurance may include one or more of the following. Ito yung mga nakalagay doon. An assurance to comply with the provisions of the IP intellectual property law. Yung IP law violated, kung ano yung na-violate mo, kailangan meron kang magbigay ka ng assurance to comply. Ikalawa, an assurance to refrain from engaging in unlawful and unfair acts and practices subject of the formal investigation. Ikatatlo, an assurance to recall, replace, repair, or refund the money value of defective goods distributed in commerce. And ika-apat, an assurance to reimburse the complainant the expenses and costs incurred in prosecuting the case in the Bureau of Legal Affairs. The Director of Legal Affairs may also require the respondent to submit periodic compliance reports and file a bond to guarantee compliance of his undertaking. O ano yung ikatatlo pa na yung number 3 na pwede niyang ilagay sa kanyang ipataw na penalty. Sabi rito, the condemnation or seizure of products which are subject of the offense. The goods seized hereunder shall be disposed of in such manner as may be deemed appropriate by the Director of Legal Affairs, such as by sale, donation to distressed local governments, or to charitable or relief institutions, exportation, pwede rin nilang gawin, recycling into other goods, or any combination thereof under such guidelines as he may provide. So, pwede niyang ipagutos yan. Ano pa yung pwede niyang kaparusahan? Ika-apat, the forfeiture of paraphernalia and all real and personal properties which have been used in the commission of the offense. Ikaliwa, the imposition of administrative fines in such amount as deemed reasonable by the Director of Legal Affairs, which shall in no case be less than 5,000 nor more than 150,000 pesos. In addition, an additional fine of not more than 100,000 pesos, of not more than 1,000 pesos shall be imposed for each day of continuing violation. Ika-anim, the cancellation of any permit, license, authority, or registration which may have been granted by the office or the suspension of the validity thereof for such period of time as the Director of Legal Affairs may deem reasonable, which shall not exceed o hindi lalagpas sa 1 year. Ikapito, na pwede niyang ipataw na kaparusahan, the withholding of any permit, license, authority, or registration which is being secured by the respondent from the office. Ikawalo, the assessment of damages. Ikasyam, censure, okay, and ikasampo, other analogous penalties or sanctions. 10.3, the Director, Section 10 pa rin tayo, ha? Sabi, the Director General may by regulations establish the procedure to govern the implementation of this section. So siguro meron na silang rules, parang pamamaraan yan kung paano nila ano yung procedure. Siguro itatap nila dyan yung policemen, di ba, to help them implement yung kanilang mga desisyon. Section 11, sorry. The Documentation, Information, and Technology Transfer Bureau. Okay? Ano naman ang function nun? Ang function niya daw ay to support the search and examination activities of the office through the following activities. Letter A, maintain and upkeep classification systems whether they be national or international, such as the International Patent Classification System, Letter B, provide advisory services for the determination of search patterns. Letter C, maintain search files and search rooms and reference libraries. And letter D, adopt and package industrial property information. Sabi rin dito, ikalawa niyang function is to establish networks or intermediaries or regional representatives. Ikatatlo, educate the public and build awareness on intellectual property through the conduct of seminars and lectures and other similar activities. Number 4, establish working relations with research and development institutions as well as with local and international intellectual property professional groups and the like. Number 5, perform state-of-the-art searches. Number 6, promote the use of patent information as an effective tool to facilitate the development of technology in the country. Number 7, provide technical advisory and other services relating to the licensing and promotion of technology and carry out an efficient and effective program for technology transfer. And number 8, kawalong function nila, register technology transfer arrangements and settle disputes involving technology transfer payments. Section 12, the Management Information Services and EDP Bureau. O ano naman yung kapangyarihan nila? They shall conduct automation planning, research and development, testing of systems, contracts with firms, contracting, purchase and maintenance of equipment, design and maintenance of systems, user consultation and the like. At ikalawa, they will provide management information support and service to the office. Section 13, the Administrative, Financial, and Human Resource Development Service Bureau shall, letter A, provide services relative to procurement and the allocation of supplies and equipment, transportation, messengerial work, cashiering, payment of salaries, and other office obligations, office maintenance, proper safety and security, and other utility services, and comply with government regulatory requirements in the areas of performance appraisal, compensation and benefits, employment records and reports. Letter B, they shall receive, itong administrative service shall receive all applications filed with the office and collect fees therefore. And letter C, publish patent applications and grants, trademark applications and registration of marks, industrial designs, utility models, geographic indication, and layout designs of integrated circuits registrations. The Patent and Trademark Administration Services shall perform the following functions, among others. So kasama doon sa mga nabanggit, ano pa yung iba nilang function? Maintain registers of assignments, mergings, licenses, and bibliographic on patents and trademarks. Collect maintenance fees, issue certificate copies of documents in its custody, and perform similar other activities. At letter C, hold in custody all the applications filed with the office and all patent grants, certificate of registrations issued by the office and the like. Yung financial service naman shall formulate and manage a financial program to ensure availability and proper utilization of funds, provide for an effective monitoring system of the financial operations of the office. Tapos yung Human Resource Development Service naman shall design and implement human resource development plans and programs for the personnel of the office, provide for present and future manpower needs of the organization, maintain high moral and favorable employee attitudes towards the organization through the continuing design and implementation of employee development programs. Section 14. Sabi rito, for a more effective and expeditious implementation of this act, the Director General shall be authorized to retain without need of a separate approval from any government agency and subject only to the existing accounting and auditing rules and regulations, all the fees, fines, royalties, and other charges collected by the office under this act and the other laws that the office will be mandated to administer for use in its operations, like upgrading of its facilities, equipment outlay, human resource development, and the acquisition of the appropriate office space, among others, to improve the delivery of its services to the public. This amount, which shall be in addition to the office annual budget, shall be deposited and maintained in a separate account or fund, which may be used or disbursed directly by the Director General. So, sana hindi nakukurakot ito, no? Income generating agency pala sila. Hindi lamang yung pera nila ay manggagaling sa pondo sa annual budget. 14.2, after 5 years from the coming into force of this act, the Director General subject to the approval of the Secretary of Trade and Industry, determine if the fees and charges mentioned in subsection 14.1 hereof that the office shall collect sufficient to meet its budgetary requirements. Ang gulo nun mali yata yung di ko maintindihan yung sinabi. If so, kung sakali siguro na aprobahan ng Secretary of Trade and Industry na sige, yung IPO shall collect ng mga fees to meet your budgetary requirements, it shall retain all the fees and charges it shall collect under the same conditions indicated in subsection 14.1, but shall forthwith cease to receive any funds from the annual budget of the national government. Okay, ang gulo nun If not, the provisions of said subsection 14.1 shall continue to apply until such time when the Director General, subject to the approval of the Secretary of Trade and Industry, certifies that the above stated fees and charges the office shall collect are enough to fund its operations. So, mahirap ito. Kailangan tropa mo si Secretary of Trade and Industry pala. Kundi hindi ka na ibibigyan ng bahagi sa national budget. Mangolekta ka na lang dyan. So, kawawa naman pag nangolekta ito, nagutom. Sus Marios. Government. Section 15, Special Technical and Scientific Assistance. The Director General is empowered to obtain the assistance of technical, scientific, or other qualified officers and employees of other departments, bureaus, offices, agencies, and instrumentalities of the government, including corporations owned, controlled, or operated by the government, when deemed necessary in the consideration of any matter submitted to the office relative to the enforcement of the provisions of this act. Section 16, Seal of Office. The office shall have a seal, the form and design of which shall be approved by the Director General. Section 17, Publication of Laws and Regulations. The Director General shall cause to be printed and make available for distribution pamphlet copies of this act, other pertinent laws, executive orders, and information circulars relating to matters within the jurisdiction of the office. Section 18, the IPO Gazette. All matters required to be published under this act shall be published in the office's own publication to be known as the IPO Gazette. Okay, so itong batas na ito pala nagki-create ng IPO Gazette. Okay. Section 19, Disqualification of Officers and Employees of Office. All officers and employees of the office shall not apply or act as an attorney or patent agent of an application for a grant of patent for the registration of a utility model, industrial design, or mark, nor acquire, except in hereditary succession, any patent or utility model, design, registration, or mark of or any right, title, or interest range during their employment and for 1 year thereafter. Okay. Tama naman yun. Kasi conflict of interest. Kapag empleyado ka ng IPO tapos bigla kang umastang attorney or patent agent ng isang applicant, di ba? O nanguha ka o nagkaroon ka ng interest sa mga models doon. And for 1 year thereafter, siguro after nag-retire ka, another 1 year, hindi ka pa pwedeng magkaroon ng interest doon except by hereditary succession. Kunwari, tatay mo yung inventor, ganun. Tungo naman tayo sa part 2. Law on Patents. Chapter 1, General Provisions. Section 20. Okay. As used in part 2, the following terms shall have the following meanings. Yung bureau daw means the Bureau of Patents, director means the Director of Patents, regulations means the rules of practice in patent cases formulated by the Director of Patents or promulgated by the Director General. Examiner means the patent examiner. Patent application or application means an application for a patent for an invention, except in Chapter 7 and 8, where application means an application for a utility model and an industrial design respectively. At ikahuli, priority date means the date of filing of the foreign application for the same invention referred to in Section 31 of this Act. Ito tayo sa Chapter 2, yung patentability, Section 21. Patentable inventions. Sabi rito, any technical solution, anumang technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable. It may be or may relate to a product or process or an improvement of any of the foregoing. Section 22, non-patentable inventions. Ano-ano sila? Discoveries, scientific theories, and mathematical methods. Hindi mo pwedeng ipapatent yan. Schemes, rules, and methods of performing mental acts, playing games, or doing business and programs for computers. Ikatatlo, methods for treatment of the human or animal body by surgery or therapy and diagnostic methods practiced on the human or animal body. This provision shall not apply to products and composition for use in any of these methods. Ikaapat, plant varieties or animal breeds are essentially biological process for the production of plants or animals. This provision shall not apply to microorganisms and non-biological and microbiological processes. Provisions under this subsection shall not preclude Congress to consider the enactment of a law providing sui generis protection of plant varieties, animal breeds, and a system of community intellectual rights protection. Ikalima, aesthetic creations. Hindi raw pwedeng ipapatent yan. Ika-anim, anything which is contrary to public order or morality. So, lahat ng mga nabanggit natin na yan ay excluded from patent protection. Section 23, novelty. An invention shall not be considered new if it forms part of a prior act. Okay? Hindi ituturing na bago ang isang invention kung bahagi na ito ng dating article. Sabi, prior article. Okay, Section 24, prior article shall consist of, anong ibig sabihin ng prior article? Hindi po yung article na nagdaang nabasa natin, kundi yung article shall be consist of, una, everything which has been made available to the public anywhere in the world before the filing date or the priority date of the application claiming the invention. And number 2, the whole contents of an application for a patent, utility model, or industrial design registration published in accordance with this act, filed or effective in the Philippines with the filing or priority date that is earlier than the filing or priority date of the application, provided that the application which has validly claimed the filing date of an earlier application under Section 31 of this Act shall be prior act with effect as of the filing date of such earlier application, provided further that the applicant or the inventor identified in both applications are not one and the same. Section 25, non-prejudicial disclosure. The disclosure of information contained in the application during the 12 months preceding, ulitin natin, during the 12 months preceding the filing date, yung bago yung the filing date or the priority date of the application shall not prejudice o hindi nito haharangan yung applicant on the ground of lack of novelty if such disclosure was made by letter A, the inventor, letter B, a patent office, and the information was contained in another application filed by the inventor and should not have been disclosed by the office, o di naman kaya in an application filed without the knowledge or consent of the inventor by a third party which obtained the information directly or indirectly from the inventor, or letter C, a third party which obtained the information directly or indirectly from the inventor. Sabi niya parito, for the purposes of subsection 25.1, inventor also means any person who, at the filing date of application, had the right to the patent. Section 26, inventive step. An invention involves an inventive step. Kung, sabi niya, if, having regarded to prior article, it is not obvious to a person skilled in the art at the time of the filing date or priority date of the application claiming the invention. Section 27, industrial applicability. An invention that can be produced and used in any industry shall be industrially applicable. Chapter 3, right to patent. Okay, karapatan na mag-patent. Section 28, the right to a patent belongs to the inventor, his heirs, or assigns. When two or more persons having jointly made an invention, the right to a patent shall belong to them jointly. Section 29, first to file rule. If two or more persons have made the invention separately and independently of each other, the right of the patent shall belong to the person who filed an application for such invention, or where two or more applications are filed for the same invention, to the applicant who has the earliest filing date or the earliest priority date. Section 30, inventions created pursuant to a commission. Sabi niya, the person who commissions the work shall own the patent unless otherwise provided in the contract. In case the employee made the invention in the course of his employment contract, the patent shall belong to, letter A, sa employee. If the inventive activity is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. Or letter B, mapupunta naman ito sa employer if the invention is the result of the performance of his regularly assigned duties, unless there is an agreement, express or implied, to the contrary. Section 31, right of priority. An application for patent filed by any person who has previously applied for the same invention in another country, which by treaty, convention, or law affords similar privileges to Filipino citizens, shall be considered as filed, okay, as of the date of filing the foreign application. Okay. Okay. So yung application for patent daw na final ng isang tao na dati na nag-apply for the same invention pero sa ibang bansa, na tayo ay party sa treaty with regards to intellectual property, it shall also be considered as filed sa atin as of the date of the filing dun sa kanyang foreign application, provided that letter A, the local application expressly claims priority. Letter B, it is filed within 12 months from the date the earliest foreign application was filed. And letter C, a certified copy of the foreign application together with an English translation is filed within 6 months from the date of filing in the Philippines. Pasensya na kayo at nahihirapan ako magsalita dahil nag-acid ako. Tuloy-tuloy ang aking acid reflux. Chapter 4, Patent Application. The patent application shall be in Filipino or English and shall contain the following. Letter A, a request for the grant of a patent. Letter B, a description of the invention. Letter C, drawings necessary for the understanding of the invention. Letter D, one or more claims. And letter E, an abstract. No patent may be granted unless the application identifies the inventor. Okay. If the applicant is not the inventor, the office may require him to submit said authority. Section 33, appointment of agent or representative. An applicant who is not a resident of the Philippines must appoint and maintain a resident agent or representative in the Philippines, upon whom notice or process for judicial or administrative procedure relating to the application for patent or the patent may be served. Section 34, the request. The request shall contain a petition for the grant of the patent the name and other data of the applicant, the inventor and the agent, and the title of the invention. Okay. So, yun pala, ano? So, meron kang patent application, tapos meron kang request. Parang petition din siya. Kaya pala sinasabi kanina na pwedeng maging patent agent or ano yung abogado, maging abogado. Kasi gagawa ka ng mga ganito request in a form of petition, no? Section 35, disclosure and description of the invention. The application shall disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. Where the application concerns a microbiological process or the product thereof and involves the use of a microorganism which cannot be sufficiently disclosed in the application in such a way as to enable the invention to be carried out by a person skilled in the art, and such material is not available to the public, the application shall be supplemented by a deposit of such material with an international depository institution. Description. The regulations shall prescribe the contents of the description and the order of presentation. Magtungo naman tayo sa Section 36, the claims. The application shall contain one or more claims which shall define the matter for which protection is sought. Each claim shall be clear and concise and shall be supported by the description. The regulations shall prescribe the manner of the presentation of the claims. Section 37, the abstract. Yung abstract daw shall consist of a concise summary of the disclosure of the invention as contained in the description, claims, and drawings in preferably not more than 150 words. It must be drafted in a way which allows the clear understanding of the technical problem, the gist of the solution of that problem through the invention, and the principal use or uses of the invention. The abstract shall merely serve for technical information. Section 38, unity of invention. The application shall relate to one invention only or to a group of inventions forming a single general inventive concept. If several independent inventions which do not form a single general inventive concept are claimed in one application, the director may require that the application be restricted to a single invention. A later application filed for an invention divided out shall be considered as having been filed on the same day as the first application, provided that the later application is filed within 4 months after the requirement to divide becomes final, or within such additional time not exceeding 4 months as may be granted. Provided further that each divisional application shall not go beyond the disclosure in the initial application. The fact that a patent has been granted on an application that did not comply with the requirement of unity of invention shall not be a ground to cancel the patent. Section 39, sabi rito, information concerning corresponding foreign application for patents. The applicant shall, at the request of the director, furnish him with the date and number of any application for a patent filed by him abroad, hereafter referred to as the foreign application, relating to the same or essentially the same invention as that claimed in the application, filed with the office, and other documents relating to the foreign application. Okay, magtungo tayo sa Chapter 5, Procedure for Grant of Patent. Section 40, Filing Date Requirements. Okay. The filing date of a patent application shall be the date of receipt by the office of at least the following elements. Ito yung mga dapat nila matanggap. Letter A, an express or implicit indication that the Philippine patent is sought. Letter B, information identifying the applicant. And letter C, description of the invention and one or more claims in Filipino or English. If any of these elements is not submitted within the period set by the regulations, the application shall be considered withdrawn. So, kailangan kompleto ka sa iyong filing requirements, no? Okay, so yun ang una mong gagawin. Mas nalinawan na ako ngayon kasi ang daming sinasabi sa mga nagdaang sections, pero ito yung filing. Section 41, according a filing date. Okay, according a filing date. The office shall examine whether the patent application satisfies the requirements for the grant of date of filing as provided in Section 40 hereof. If the date of filing cannot be accorded, the applicant shall be given an opportunity to correct the deficiencies in accordance with the implementing regulations. If the application does not contain all the elements indicated in Section 40, the filing date should be that date when all the elements are received. If the deficiencies are not remedied within the prescribed time limit, the application shall be considered withdrawn. Okay. Section 2, formality examination. After the patent application has been accorded a filing date and the required fees have been paid on time in accordance with the regulations, the applicant shall comply with the formal requirements specified by Section 32 and the regulations within the prescribed period. Otherwise, the application shall be considered withdrawn. The regulations shall determine the procedure for the re-examination and revival of an application, as well as the appeal to the Director of Patents from any final action by the examiner. Section 43, classification and search. An application that has complied with the formal requirements shall be classified and a search conducted to determine the prior act. Section 44, publication of patent application. The patent application shall be published in the IPO Gazette together with the search document established by or on behalf of the office, citing any documents that reflect prior art after the expiration of 18 months from the filing date or priority date. Tagal din, ha? Okay. Okay. So matapos yung 18 months from the filing date, itong patent application ay ipapublish sa IPO Gazette, no? Kasama ng mga search documents. Okay. Ikalawa, after publication of a patent application, any interested party may inspect the application documents filed with the office. So kahit na sinong interested party, no? Ikatatlo, the Director General, subject to the approval of the Secretary of Trade and Industry. Kasi nga sabi, di ba, yung Director General, pinakamataas sa IPO. Siya ay under the supervision of the Department of Trade, the Secretary of Department of Trade and Industry. So, they may prohibit or restrict the publication of an application if, in his opinion, to do so would be prejudicial to the national security and interests of the Republic of the Philippines. Section 45. Confidentiality before publication. A patent application which has not yet been published and all related documents shall not be made available for inspection without the consent of the applicant. Kailangan may pahintulot naman ng aplikante para inspeksyonin na kung sino-sino mga taong interested. Section 46, rights conferred by a patent application after publication. The applicant shall have all the rights of a patentee under Section 76 against any person who, without his authorization, exercised any of the rights conferred under Section 71 of this Act in relation to the invention claimed in the published patent application, as if a patent had been granted for that invention. Wala pa siyang patent pero may karapatan na siya ng isang patentee, provided that the person had, number one, actual knowledge that the invention that he was using was a subject matter of a published application. Ayun, meron ng rights yung patentee. Okay, yung nag-a-apply ng patent. Kung yung taong kinakalaban niya, kumbaga, ay merong actual knowledge na yung invention that he was using was a subject matter of a published application. Ikalawa, received, nakatanggap siya ng written notice that the invention that he was using was the subject matter of a published application being identified in the said notice by its serial number, provided that the action may not be filed until after the grant of a patent on the published application and within 4 years from the commission of the acts complained of. Section 47, Observation by third parties. Following the publication of the patent application, any person may present observations in writing concerning the patentability of the invention. Such observations shall be communicated to the applicant who may comment on them. The office shall acknowledge and put such observations and comment in the file of the application to which it relates. Okay, Section 48, Request for Substantive Examination. The application shall be deemed withdrawn unless within 6 months from the date of publication under Section 41, a written request to determine whether a patent application meets the requirements of Sections 21 to 27 and Sections 32 to 39 and the fees have been paid on time. Withdrawal of the request for examination shall be irrevocable and shall not authorize the refund of any fee. Section 49, Amendment of Application. An applicant may amend the patent application during examination provided that such amendment shall not include new matter outside the scope of the disclosure contained in the application as filed. Magtungo naman tayo, grant of patent. Sabi niya, if the application meets the requirements of this act, the office shall grant the patent provided that all fees are paid on time. If the required fees for grant and printing are not paid in due time, the application shall be deemed to be withdrawn. Grabe naman sila, no? Kailangan to be paid in due time. Paano kung walang pera yung inventor natin? A patent shall take effect on the date of the publication of the grant of the patent in the IPO Gazette. So, ibig sabihin, may epekto na. Nagtitake effect na yung patent mo kapag ka nai, nai, nai-publish na siya sa IPO o International Intellectual Property Office Gazette. Section 51, Refusal of Application. The final order of refusal of the examiner to grant the patent shall be appealable to the director in accordance with this article. The regulations shall provide for the procedure by which an appeal from the order of refusal from the director shall be undertaken. Section 52, Publication upon grant of patent. The grant of patent together with other related information shall be published in the IPO Gazette within the time prescribed by the regulations. Any interested party may inspect the complete description, claims, and drawings of the patent on file with the office. Section 53, Contents of the patent. The patent shall be issued in the name of the Republic of the Philippines under the seal of the office and shall be signed by the director and registered together with the description, claims, and drawings, if any, in books and records of the office. Section 54, Term of Patent. The term of a patent shall be 20 years from the filing date of the application. Rest muna ako at ako'y magbabalik. Okay, ako po yung nagbabalik. Okay. Pasadahan natin ang Section 55, no? Annual fees. Sabi rito, to maintain the patent application or patent, an annual fee shall be paid upon the expiration of 4 years from the day the application was published, pursuant to Section 4 hereof, and on each subsequent anniversary of such date. Payment may be made within 3 months before the due date. The obligation to pay the annual fees shall terminate should the application be withdrawn, refused, or cancelled. So, grabe naman to. Habang nakabinbin yung application sa kanila, magbabayad ka ng uh, annual fee. Parang I'm starting to dislike this international property code. If the annual fee is not paid, the patent application shall be deemed withdrawn. Wow! Or the patent considered as lapsed from the day following the expiration of the period within which the annual fees were due. A notice that the application is deemed withdrawn or the lapse of a patent for non-payment of any annual fee shall be published in the IPO Gazette, and the lapse shall be recorded in the register of the office. A grace period of 6 months shall be granted for the payment of the annual fee upon payment of the prescribed surcharge for delayed payment. Section 56, Surrender of Patent. The owner of the patent, with the consent of all persons having grants or licenses or other right, title, or interest in and to the patent and the invention covered thereby, which have been recorded in the office, may surrender his patent or any claim or claims forming part thereof to the office for cancellation. Any person may give notice to the office of his opposition to the surrender of a patent under this section, and if he does so, the Bureau shall notify the proprietor of the patent and determine the question. If the office is satisfied that the patent was properly be surrendered, he may accept the offer, and as from the day when notice of his acceptance is published in the IPO Gazette, the patent shall cease to have effect, but no action for infringement shall lie, and no right compensation shall accrue for any use of the patented invention before that day for the services of the government. Section 57, Correction of Mistakes of the Office. The director shall have the power to correct without fee any mistake in a patent incurred through the fault of the office when clearly disclosed in the records thereof, to make the patent conform to the records. Section 58, Correction of Mistake in the Application. On request of any interested person and payment of the prescribed fee, the director is authorized to correct any mistake in a patent of a formal and clerical nature not incurred through the fault of the office. Section 59, Changes in Patents. The owner of a patent shall have the right to request the Bureau to make the changes in the patent in order to, letter A, limit the extent of the protection conferred by it, letter B, correct obvious mistakes or to correct clerical errors, and letter C, correct mistakes of errors other than those referred to in letter B, made in good faith. Provided that where the change would result in a broadening of the extent of protection conferred by the patent, no request may be made after the expiration of 2 years from the grant of a patent, and the change shall not affect the rights of any third party which has relied on the patent as published. No change in the patent shall be permitted under this section where the change would result in the disclosure contained in the patent going beyond the disclosure contained in the application filed. If and to the extent to which the office changes the patent according to this section, it shall publish the same. Section 60. Form and publication of amendment. An amendment or correction of a patent shall be accomplished by a certificate of such amendment or correction, authenticated by the seal of the office and signed by the director, which certificate shall be attached to the patent. Notice of such amendment or correction shall be published in the IPO Gazette, and copies of the patent kept or furnished by the office shall include a copy of the certificate of amendment or correction. Chapter 6. Cancellation of patents and substitution of patentee. Any interested person may, upon payment of the required fee, petition to cancel the patent or any claim thereof or parts of the claim on any of the following grounds. Letter A, that what is claimed as the invention is not new or patentable. Letter B, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art. Or letter C, that the patent is contrary to public order or morality. Where the grounds for cancellation relate to some of the claims or parts of the claim, cancellation may be effected to such extent only. Section 62, requirement of the petition. The petition for cancellation shall be in writing, verified by the petitioner or by any person in his behalf who knows the facts, specify the grounds upon which it is based, include a statement of the facts to be relied upon, and filed with the office. Copies of printed publications or of patents of other countries and other supporting documents mentioned in the petition shall be attached thereto, together with the translation thereof in English, if not in English language. Ang hirap naman pala, no? Ang daming mga proseso sa pangunguhan ng pagsisecure ng patent. Kakailanganin mo ng abogado pag may kumontra, mga babayaran, mga sangkaterbang fees. Yung inventor na ordinaryong tao lamang, matalino lang talaga siya at maparaan. Paano siya makakasecure ng patent dito sa ganitong... Ewan ko, I'm sorry, hindi. Section 63, Notice of Hearing. Upon filing of a petition for cancellation, the Director of Legal Affairs shall forthwith serve notice of the filing thereof upon the patentee and all persons having grants or licenses or any other right, title or interest in and to the patent and the invention covered thereby, as appears of record in the office, and of notice of the date of hearing thereon on such persons and the petitioner. Notice of the filing of the petition shall be published in the IPO Gazette. Section 64, Committee of Three. In cases involving highly technical issues on motion of any party, the Director of Legal Affairs may order that the petition be heard and decided by a committee composed of the Director of Legal Affairs as chairman and 2 members who have the experience or expertise in the field of technology to which the patent sought to be cancelled relates. The decision of the committee shall be appealable to the Director General. Section 65, Cancellation of a patent. If the committee finds that the case for cancellation has been proved, it shall order the patent or any specified claim or claims thereof cancelled. If the committee finds that, taking into consideration the amendment made by the patentee during the cancellation proceedings, the patent and the invention to which it relates meet the requirement of this act, it may decide to maintain the patent as amended, provided that the fee for printing of a new patent is paid within the time limit prescribed in the regulations. If the fee for the printing of new patent is not paid in due time, the patent should be revoked. Wala na palang fee. Puro fee, ano? If the patent amended under subsection 65.2 hereof, the Bureau shall, at the same time as it publishes the mention of the cancellation decision, publish the abstract, representative claims, and drawings indicating clearly what the amendments consist of. Section 66, Effect of cancellation of patent or claim. The rights conferred by the patent or any specified claim or claims cancelled shall terminate. Notice of the cancellation shall be published in the IPO Gazette. Unless restrained by the Director General, the decision or order to cancel by Director of Legal Affairs shall be immediately executory even pending appeal. Chapter 7, Remedies of a person with the right to a patent. Okay. If a person referred to in Section 29 other than the applicant is declared by final court order or decision as having the right to the patent, such person may, within 3 months after the decision has become final, letter A, prosecute the applicant as his own application in place of the applicant. Okay. Letter B, file a new patent application in respect of the same invention. Oh, kasi napatunayan ng korte na siya yung rightful, siya yung may karapatan doon sa patent. Pero ibang usapan yun, no? Merong court order, hindi ibig sabihin, pinagtalunan muna sa korte, no? Letter C, request that the application be refused. Ibig sabihin yung application nung kalaban niya na tinalo niya sa korte. And letter D, seek cancellation of the patent if one has already been issued. The provisions of subsection 38.2 shall apply mutatis mutandis to a new application filed under subsection 67.1. Ano nang mang ibig sabihin ng mutatis mutandis? Mutatis mutandis. Hanapin nga natin. Mutatis. Ano ba meaning nito, Kon? So, used when comparing two or more cases or situations, making necessary alterations while not affecting the main point at issue. What is true of undergraduate teaching in English is equally true mutatis mutandis of American graduate school. So, yun ang example niya. So, kinukumpara mo yung dalawa ng, okay, so sabi niya shall apply mutatis mutandis to a new application. Okay, so yung sabi niya lang dito, the provisions of subsection 38.2 shall apply, kumbaga similarly or the same in comparison to a new application filed under subsection 67.1. Section 68, remedies of the true and actual inventor. If a person who was deprived of the patent without his consent or through fraud is declared by final order or decision to be the true and the actual inventor, the court shall order for his substitution as patentee or the option of the true inventor, cancel the patent and award actual and other damages in his favor if warranted by circumstances. You know, ang hirap lang nito kasi imagine mo, kunwari nagtalo kayo, nag-file sa korte, hindi ko lang alam kung anong case ang fina-file, kunwari nabalitaan ko yung invention ko ay kinuha ni Pedro, tapos si Pedro nagpa-file na sa Intellectual Property Office. Then nag-file ako sa korte, kunwari, ng kaso. Ano kayang tawag doon? Petition for judicial determination of the rightful patentee. Pwede ba yun? May ganun bang kaso sa korte? Hindi ko alam. So, kunwari, nagganon ako. Kasi court ang sinasabi niya rito. So, baka trial court. So, nanalo ako na ako yung inventor. Gumastos na ako para patunayan ko na ako yung tunay na may-ari nun. Gagastos pa ulit ako para kansilahin ko yung patent nung ni Pedro na nagnakaw ng invention ko. Dala-dala ko syempre yung court order, no? Sabi niya, oh. Sabi kasi 69, no? Publication of the court order. The court shall furnish the office, itong IPO nga, a copy of the order or decision referred to in section 67-68, which shall be published in the IPO Gazette within 3 months from the date such order or decision became final and executory, and shall be recorded in the register of the office. So, gumastos na ako sa korte, dadaling ko pa yung desisyon ng korte sa IPO. Magbabayad pa ako ng mga nagdaang nabanggit natin na petition for cancellation o na kung may patent nang naibigay sa kanya or whatever. Tapos magbabayad pa ako ng pampublication, di ba? Section 70, time to file action in court. The actions indicated in section 67 and 68 shall be filed within 1 year. Okay? Within 1 year from the date of publication, made in accordance with sections 44 and 51. Ulitin natin, made in accordance with sections 54 and 51 respectively. Oh, wait lang ha. Hello, boys. Ano? Ano? Kaya okay lang naman kumain ka ba? Nagpahinga ka lang maghapon? Natulog ka? Makakatulog ka pa kaya niya mamaya? Pagod ka, ano? Kaya mong matulog maghapon magdaman. I-rest ka muna after nito maliligo. Bye-bye. Sandali ko. Nalay. Okay, pasensya na po kayo at may tumawag lang ang aking kasintahan at pasensya na rin kayo na lagi pag nagbabasa ako ng batas may mga side comments ako kasi hindi ko nakikita na favorable sa mahihirap yung iba nating mga batas. Tulad nito, kung may isang mahirap na inventor, kailangan nyo pa ng middleman o ng sponsor na makikihati sa kung anong kikitain niya para lamang makakuha man lang siya ng patent or laging ganon, hindi man lang pwedeng frustrating lang talaga ano. Chapter 8, Rights of Patentees and Infringement of Patents. Section 71, a patent shall confer on its owner the following exclusive rights. Letter A, where the subject matter of a patent is a product, okay, may karapatan siya to restrain, prohibit, and prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. Letter B, where the subject matter of a patent is a process, may karapatan siya to restrain, prevent, or prohibit any unauthorized person or entity from using the process and from manufacturing, dealing in, using, selling, or offering for sale, or importing any product obtained directly or indirectly from such process. Patent owners shall also have the right to assign or transfer by succession the patent and to conclude licensing contracts for the same. So, pwedeng ipamana sa iyong mga magiging anak itong patent. Section 72, Limitations of Patent Rights. The owner of a patent has no right to prevent third parties from performing without his authorization the acts referred to in Section 71 hereof in the following circumstances. Okay. Medyo naguluhan ako doon. Number 1, using a patented product which has been put on market in the Philippines by the owner of the product or with his express consent insofar as such use is performed after the product has been so put on the said market. Pag nailagay na sa market, wala ka naman ng karapatang pagbawalan siyang gamitin yung product na yun. Number 2, where the act is done privately and on a non-commercial scale or for a non-commercial purpose, provided that it does not significantly prejudice the economic interests o hindi siya nakakaperwisyo sa economic interests of the owner of the patent. Ikatatlo, where the act consists of making or using exclusively for the purpose of experiments that relate to the subject matter of the patented invention. So pag ganon, walang karapatan tong si owner ng patent na pigilan sila. Ikaapat, where the act consists of the preparation for individual cases in a pharmacy or by a medical professional of a medicine in accordance with the medical prescription or acts concerning the medicine so prepared. At ikalima, where the invention is used in any ship, vessel, aircraft, or land vehicle of any other country entering the territory of the Philippines temporarily or accidentally. So nagamit ng mga ship, vessel, aircraft, or land vehicle na pumapasok sa teritoryo ng Pilipinas yung iyong gawa accidentally. Provided that such invention is used exclusively for the needs of the ship, vessel, aircraft, or land vehicle and not used for the manufacturing of anything to be sold within the Philippines. Section 73, prior user. Sabi rito, notwithstanding Section 72 hereof, any prior user who in good faith was using the invention or has undertaken serious preparations to use the invention in his enterprise or business before the filing date or priority date of the application in which a patent is granted shall have the right to continue the use thereof as envisaged in such preparations within the territory where the patent produces its effects. So kung bago pa yung filing date o yung tinatawag na priority date, yun yung dalawang basihan sa pagbibigay ng patent, bago pa yun ay ginagamit mo na in good faith para sa preparasyon ng iyong negosyo or whatsoever, may karapatan ka para gamitin yun kahit na may ma-issuehan na ng patent yung inventor nung bagay na yun o yung nag-grant na ng patent yung rightful owner or inventor, yung tamang case nung product na yun. The right of the prior user may only be transferred or assigned together with his enterprise or his business or with that part of his enterprise or business in which the use or preparations for use have been made. Section 74, use of invention by government. Wala kang laban dito, gobyerno ito A government agency or third person authorized by the government may exploit the invention even without agreement of the patent owner where letter A, the public interest, in particular national security, nutrition, health, or the development of other sectors as determined by the appropriate agency of the government so requires, or letter B, a judicial or administrative body has determined that the manner of exploitation by the owner of the patent or his licensee is anti-competitive. The use by the government or third person authorized by the government shall be subject mutatis mutandis, in comparison to the conditions set forth in sections 95 to 97 and 100 to 102. Section 75, the extent of protection conferred by the patent shall be determined by the claims which are to be interpreted in the light of the description and drawings. For the purpose of determining the extent of protection conferred by the patent, due account shall be taken of elements which are equivalent to the elements expressed in the claims, so that the claim shall be considered to cover not only all the elements as expressed therein, but also equivalents. Section 76, civil action for infringement. Sabi niya rito, the making, using, offering for sale, or importing a patented product or a product obtained directly or indirectly from a patented process or the use of a patented process without the authorization of the patentee constitutes patent infringement. Any patentee o yung napagkalooban ng patent or anyone possessing any right, title, or interest in and to the patented invention whose rights have been infringed may bring a civil action before a court of competent jurisdiction to recover from the infringer such damages sustained thereby. Ito yung ang tawag dito, petition for damages, plus attorney's fees and other expenses of litigation, and secure an injunction for the protection of his rights. So yung application for writ of preliminary injunction plus damages. Hilingin niya sa korte na ipatigil sa iyo yung paggagamit mo, paggawa mo, o pagbili mo, o pagbenta mo sa produkto niya, at maghihingi siya ng bayad na danyos. If the damages are inadequate or cannot be readily ascertained with reasonable certainty, the court may award by way of damages a sum equivalent to reasonable royalty. The court may, according to the circumstances of the case, award damages in a sum above the amount found as actual damages sustained, provided that the award does not exceed 3 times the amount of such actual damages. So parang ito yung pinakamahalaga dito sa mga nag-aaral ng batas, no? Kasi they're talking about the court. Nagfa-file ka sa court ng damages, no? Dahil sa dahil sa patent infringement. Sabi pa rito, the court may, in its discretion, order that the infringing goods, materials, and implements predominantly used in the infringement be disposed of outside the channels of commerce or destroyed without compensation. Anyone who actively induces the infringement of a patent or provides the infringer with a component of a patented product or of a product produced because of a patented process, knowing it to be especially adapted for infringing the patented invention and not suitable for substantial non-infringing use, shall be liable as a contributory infringer and shall be jointly and severally liable with the infringer. Okay? So kapag ikaw ay actively induces infringement, kumbaga ikaw ay nanggagatong, ikaw ay nagbibigay ng mga pagkakataon para mag-infringe. Okay? Dalawa kayo nung mismong gumagawa ng paglabag, no? Na jointly and severally liable kayo. Section 77, infringement action by foreign national. Any foreign national or juridical entity who meets the requirements of Section 3 and not engaged in business in the Philippines, to which a patent has been granted or assigned under this act, may bring an action for infringement of patent, whether or not it is licensed to do business in the Philippines under existing law. So, ang foreign national pala, o yung foreign corporation, which is a judicial entity, basta daw na-meet niya yung requirement ng Section 3 na hindi siya engaged in business in the Philippines, okay, may bring an action for infringement of patents, sabi. Section 78, process patents at yung burden of proof. Sabi niya rito, if the subject matter of a patent is a process for obtaining a product, sabi niya, any identical product shall be presumed to have been obtained through the use of the patented process if the product is new or there is substantial likelihood that the identical product was made by the process and the owner of the patent has been unable, despite reasonable efforts, to determine the process actually used. In ordering the defendant to prove that the process to obtain the identical product is different from the patented process, the court shall adopt measures to protect, as far as practicable, his manufacturing and business secrets. Section 79, limitation of action for damages. No damages can be recovered for acts of infringement committed for more than 4 years before the institution of the action for infringement. Okay. So sa pagitan lamang ng 4 na taon bago ka mag-file ng action for infringement, yung ginawa niya lang sa pagitan ng 4 na taon na yun, before ka magreklamo, yun lang ang pwede mo i-claim. Hindi yung pwede yung infringement para sa'yo na ginagawa niya 10 years ago. Within the period of 4 years lang, yung acts niya during that time before you file the action for infringement. Section 80, damages. Requirement of notice. Damages cannot be recovered for acts of infringement committed before the infringer had known or had reasonable grounds to know of the patent. It is presumed that the infringer had known of the patent if on the patented product or on the container or package in which the article is supplied to the public or on the advertising material relating to the patented product or process are placed the words Philippine patent with the number of the patent. Okay. So kung wala namang ganun yung produkto mo, wag ka na magreklamo ng damages. Section 81, defenses in action for infringement. In an action for infringement, the defendant, in addition to other defenses available to him, may show the invalidity of the patent or any claim thereof on any of the grounds on which a petition of cancellation can be brought under Section 61 hereof. Section 82, patent found invalid may be cancelled. In an action for infringement, if the court shall find the patent or any claim to be invalid, it shall cancel the same, and the director of legal affairs, upon receipt of the final judgment of cancellation by the court, shall record the fact in the register of the office and shall publish a notice to that effect in the Intellectual Property Office Gazette. Okay. So, pwede kang mag-file sa korte nito. Okay. Section 83, assessor in infringement action. 2 or more assessors may be appointed by the court. The assessors shall be possessed of the necessary scientific and technical knowledge required by the subject matter in litigation. Either party may challenge the fitness of any assessor proposed for appointment. Each assessor shall receive a compensation in an amount to be fixed by the court and advanced by the complaining party, which shall be awarded as part of his costs should he prevail in the action. Section 84, criminal action for repetition of infringement. If infringement is repeated by the infringer or by anyone in connivance with him after finality of the judgment of the court against the infringer, the offender shall, without prejudice to the institution of a civil action for damages, be criminally liable therefore, and upon conviction shall suffer imprisonment for the period of not less than 6 months, but not more than 3 years, and or a fine of not less than 100,000 pesos, but not more than 300,000 pesos at the discretion of the court. The criminal action herein provided shall prescribe in 3 years from the date of the commission of the crime. So kung inulit mo raw yung infringement, merong pwede kang file ng criminal case, which is yung repetition of infringement. Nag-ask na siya ng damages sa'yo, kunwari, at ng petition for, ang tawag dito, hindi pala, preliminary injunction. O, pinatigil ka na ng korte, natalo ka na, ginawa mo pa ulit. So, ang tawag doon ay repetition of infringement. Okay. So, ayun na, natapos natin yung, ang tawag dito, yung legal aspect, no? Yung mga legal aspect ng, o yung aspetong dapat malaman ng isang abogado, kunwari, pagdating sa Intellectual Property Code. Yung iba, tutuloy natin yung Chapter 9, Voluntary Licensing. Okay, may mga prohibited clauses din yan eh. Babasahin natin ulit sa next edition natin ng pagbabasa natin ng mga batas, okay? So, nagtapos tayo ngayon, Section 83. Bago tayo magpaalam, magdasal muna tayo. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. So, maraming salamat sa lahat ng sumusuporta sa channel nito. At maraming salamat sa lahat na nakikinig. Sana po ay natuto kayo. At next time, sama-sama na naman tayo magbasa ng mga batas at subukan natin itong ipaliwanag in layman's term. So God bless and good night.